Assalamualaikum warahmatullahi wabarakatuh. My name is Fihmi bin Muhammad Faiz, and I would like to talk about discharge of contract. What is discharge of contract? Discharge of contract. When two or more parties enter into a contract, each of them has duties or obligations arising from the contract. For example, if he is seller, deliver the goods sold to the buyer. If he is the buyer, under duty to pay the price agreed. Modes of discharge of contract. The contract may be discharged by any one of the following modes. First, by performance of the contract. Second, by consent or agreement between the parties of the contract. Third, by impossibility or frustration. Fourth, by breach of contract by any one of the parties. Discharge by performance. Discharge by performance, usual mode of discharging a contract. Under a contract, the parties to the contract are bound to perform their part in the contract. For example situations, Amru wants to sell his house at Kampung Air Merah worth 500,000 ringgit. The issue whether Kashaf and Lisa has performed their duties to the contract are completely or not. Under Section 2A and Section 3A1, Section 2A provides that when one person signifies willingness to do or abstain from doing with a view to obtain assent of the other. According to Section 3A1 provides that parties to a contract must either perform or offer to perform their respective promise unless such performance has been disposed by any law. In this situation, performance must be exact and precise in accordance with the terms of the contract. Lisa has performed her duties while Kashaf not performed his duties because he is still bounded by the contract until he handed the house to Lisa. Performance of contract must be within the scope, terms and conditions of each contract. If time and place is prescribed in a contract, the parties must follow the time and perform the contract at the place that has been specified. In this case, there is no specific time and place that have stipulated. So, Lisa has a right to pay the house to Kashaf at any time and anywhere. After Lisa paid the price of the house, Kashaf then transferred the house to her. Discharge by agreement. Where contract may be discharged when parties to the contract agree under free consent to discharge obligation from the former contract. However, what happens if there are upcoming change heard by one party and they wish to reinforce their obligations? Based on Section 63 Contract Act 1950, if the parties to a contract agree to replace or withdraw or fix into a new contract, it is not necessary to perform the original contract. An ARR, which is novation, alteration, rescission, remission. An ARR, agreement of contract, can be in the following forms. Example of situation. Sapwan has a money crisis in his family, so he needs to borrow some money from Shoaib to solve his family problem. After having a discussion with Shoaib, Shoaib lent him about 3,000 ringgit and Sapwan made a deal to pay it back. 3 months after that, Sapwan met with Shoaib. He told Shoaib that he does not have any money to pay it back to Sapwan, so he changed the payment method by mortgage his motorcycle that was 3,000 ringgit. Shoaib just accepted the offer and the deal is done. So, as we can see, when Sapwan did not have enough money to pay Shoaib, he made a new agreement. In other words, he has altering the original contract and there is a new contract and extinguish the old. Based on Act Section 64 Contract Act 1950, which is remission of performance, where every promise may dispense with or remit wholly or in part the performance of the promise made to him, or may accept instead of it any satisfaction which he thinks fits it. So we can conclude that discharge of agreement is where the parties must agree with willingness to terminate the contract. It also must have agreement from each party with freely given. Discharge by impossibility. Discharge by impossibility. A contract is discharged if there is impossibility of performance of the contract. Situation. Nasuha, going to attend the fashion show as model at Chin Hotel. The contract is on 2nd April to 5th April 2021 at the hotel's hall. Both parties agreed to enter a contract. Nasuha was paid 50% of the deposit payment. However, on 31st March to 7th April, the flight from Terengganu to KL was cancelled due to bad weather. Issue: whether XX Event Company can take action against Nasuha and whether there are remedies available to them. Under frustration, there are two sections. Section 57, the contract itself cannot be performed. The contract can discharge either one or both parties are aware of impossibility to perform the contract. Another section, which is section 57(2), it provides that contract can become impossible to be performed after it was made due to subject matter as death, personal incapacity, or change in law. Continue for the case situation. So in this case, Wahida cannot attend the fashion show on the date being promised because of supervening, which defeat the purpose of the contract. She was claimed to be breached her duty. Remedies: a right can be claimed by a party to a contract that experienced losses because of the other party to the contract was in breach. Based on this case, Nasuha need to give back the 50% of deposit payment to the XX Event Company. So we can conclude that XX Event Company can take action against Nasuha because she failed to perform and rescind the contract between them. Next, discharge by breach of contract. Discharge by breach of contract, a contract that is released from its execution if any party under the contract fails to meet its obligation as agreed in accordance with the terms and conditions of the contract. Based on Section 40 of Contract Act, when a party to contract has refused to perform, disable himself from performing his promise in its entirely, the promise may put an end to the contract unless he has signified by words or conduct his acquiescence in its continuance. Example of situation: Zavi asked Kim to build small playground in front of her house to her kids. Kim accepts the job, but he needs Zavi to make payment first in order to him buy all the necessary equipment. Zavi agreed and make the payment. After accept the payment, Kim proceed the project as promised. Zavi was very satisfied with Kim's performance until one day Kim only done half of the playground. Zavi feels so upset and she wants to take legal action against him. Based on the situation, the remedies available are claims for damage as Zavi already made the full payment. Damage is compensation to enable the innocent party to receive a monetary compensation from the party who is responsible for the breach of contract. That's all. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Shakir Ismail. Today I'm going to present about remedies for breach of contract. First one is rescission of contract. Rescission of contract when a party to a contract has refused to perform or disable himself from performing his promise in its entirety. The promise may put an end to the contract unless he has signified by words or his acquiesce in its continuance. Example: A singer enters into a contract with B, the manager of the theatre, to sing at the theatre 2 nights in every week during the next 2 months, and B engaged to pay her RM 900 for each night's performance. On 6th night, A will fully absent herself from the theatre. B is at liberty to put an end to the contract. Next is damage. There are 4 types of damage. First one is damage arising naturally, ordinary damage. There are damage for any loss caused thereby which naturally arose according to the usual costings resulting the breach. Example: A contact to repair B's house in certain manners and receive payment in advance. A repairs the house and B not according to the contract. B, entitled recover at the cost making repair from the contract. Next one is B. B, section damage for any special loss sustained. It is compensation for any loss of damage caused by the breach of contract is known as person breach. The defendant could anticipate lost profit by plaintiff if the defendant is the breach of contract. The similar case of this special damage for any special loss sustained is a case of Kyoto versus Associated Metal Smelters. Next is liquidated damage. The parties have stated in the contract the amount of the damage to be paid in the event of a breach. In addition, the stated amount is the maximum limit of compensation that can be claimed if there a breach. Is similar with section 75. When a contract has been broken, if a sum is named, the contract as the amount to be paid in case such breach, or if the contract contains any other stipulation by way of penalty. Next, categories of damage. There are three types categories of damage. First one is substantial damage, nominal damage, and lastly, exemplary damage. Let's move to special performance. Special performance is an order of the court directing the party who commits breach of contract to do what he has promised to do. It compels the contracting party who is in breach of the contract to fulfill his obligation under the contract to perform the contract as agreed. There are situations where the specific performance may be granted and cannot be granted. Next one is first one is section 11 subsection 1 subsection A. When an act agreed to be done, its performance wholly or partly of the trust. Next one is section 11 subsection 1 subsection B. When there exists no standard for ascertaining the casual damage caused by the non-performance of the contract agreed to be done. Example, A agreed to buy and B agreed to sell a picture of that painter and two rare china vases. A may compel B specifically to perform this contract, for there is no standard for ascertaining the actual damage which would be caused by non-performance. Next, section 11, subsection 1, subsection C. When the act to be performed is such that its non-performance would be afford adequate relief. The relevant case in Can Realty Sdn Bhd and ORS versus Nicholas ORS. In this case, the defendant agreed to sell their shares to the plaintiff. Plaintiff claimed specific performance when defendant refused to fulfill the contract. It was argued for the applicants that the agreement was incapable of specific performance. The court dismissed the application. Specific performance was granted to enforce a promise to sell certain. Next, last one, section 11, subsection 1, subsection D. When it is probable that pecuniary compensative cannot be got from the non-performance of the act agreed to be done. Example, A transfer without endorsement, but for valuable consideration, A promissory notes to B. A becomes insolvent and C is appointed his assignee. B may compel C to endorse the note. For C succeed, A's liabilities and decree for pecuniary compensation for not endorsing the note would be fruitless. Next one is situation where specific performance cannot be granted. There are 10 ways of that. First one is a contract for non-performance, which money compensation is adequate relief. Number two is the contract which runs into such minutes or numerous details. Third one, a contract which is so dependent on the personal qualification or volition of the parties, such as contract employment. Next one is contract requiring supervision by a court, such as building contract. Next one is a contract, the terms of which courts cannot be fined the reasonable certainly. Next one is a contract which is in the nature revocable, such as contract of partnership or no fixed duration. Next one is a contract made by trustee either in excess of their powers or in breach of their trust. For example, A is trustee of land with power to lease it for 7 years. He enters into a contract with B to grant to lease of land 7 years, with a covenant to renew the lease at the expiry of the term. This contract cannot be specifically enforced. Next one is contract made by or on behalf of a corporation, public company, created for special purpose. Next one is a contract that perform, which involve performance of a continuous duty extending the period of longer than 3 years a day. Last one is a contract which the material part of the subject matter supposed by both parties to exist as before the contract is made, his causes to exist. Next example, a contract to pay annuity to B for belief C and D. It's turned out that at the date of the contract, C, through supposed by A and B to be alive, was dead. The contract cannot be specifically performed. Next one is injunction. There are two types of injunction. First one is temporary injunction, temporary or interim injunction, to continue specific time until further order of the court. It may be granted at any period of suit as regulated by law relating to the civil procedure. Next one is the similar case of the permanent injunction is the American Ceramic Company versus Ethicon. Next one is permanent perpetual injunction. It will be given after trial's final judgment. Permanent order can only be granted by the decree made at the hearing and upon the merits of suit. The defendant is terribly perpetually enjoy the association right or its commission of an act which would be contrary to rights of plaintiff. This is similar to case of Neo Sing Ng versus Tu Chi Kong. Lastly is quantum merit. Quantum merit is claimed for reasonable remuneration for work done of service supplied under the contract in the event of a breach of contract. There are two kinds of quantum merit. First one is where one party abandons or refuses to perform the contract. Then last one is where work has been performed and accepted under the void of contract. That's all from me. Thank you very much.